Good morning, everybody. By the previous video, we have completed our discussions up to Article 264. Today, I will discuss Article 265. In fact, it is an article of single line. Article 265 is an important provision in defining financial relationships between the union and the centers. Article 265 states that no taxes shall be levied or collected save as per law. So, taxation is a legislative function. Taxation is a levy, collecting of money from the people, of course, by force. Any levy by the government should be through law, and of course, it is only forceful collection. These are not voluntary donations. As regards the union is concerned, they are imposing taxes as laid down in the budget of each year, which usually comes in the month of February. We popularly call it budget, but in constitutional parlance, it is an annual financial statement. This would contain all receipts and expenditure of capital and revenue nature, and the proposals to raise the revenues, etc., through any new enactment also would be contained through direct and indirect taxes. Accordingly, the state would have a plan of receipts and expenditure, and the citizens also would be able to plan their financial affairs in accordance with the plan of the state. This should happen under Article 112. This annual financial statement will have to be introduced or caused to be introduced by the president, not anybody else. And annual financial statement of the states under Article 202 has to be introduced in the state legislatures by the governor of that state or anybody on his behalf. The same conditions apply. All receipts and expenditure of the state would be mentioned in the annual financial statement. Accordingly, people would plan their financial affairs. In my observation, states are not following this discipline. Budget, they are using it as a populist method to catch vote banks. They announce something ambitious, development and social welfare schemes, and ultimately they fail to implement them due to paucity of funds. The chief ministers announce freebies unwanted and unwarranted from the election diocese. We have discussed in our earlier videos that such a practice is an illegal and unconstitutional practice. No expenditure can be planned without consent of the governor of that state. Ministers or chief ministers are not authorized to propose new expenditure without being discussed in the state legislative assemblies. To meet these freebies, expenditure on account of these freebies, states are often issuing departmental circulars, maybe by the municipality, the mining, road transportation, etc., various departments, and levying new taxes through these departmental circulars. You might have noticed several such new tax, fees, and cess through departmental circulars. Unfortunately, they are terming as GOs. GO should be a governor's ordinance, that should be a government order. But whereas these departmental circulars, which are like circulars of the Central Board of Direct Taxes or the GST Council, these departmental heads are issuing orders indiscriminately and terming them as GOs. But these GOs do not have force of law. It is quite unjustified. People cannot be caught unaware in the middle of the year if you charge any tax, fees, cess or other things. How would they plan their business affairs? And especially such of the levies are there which are neither direct tax nor indirect tax. Direct taxes are those like income tax, which is payable from the earnings of a citizen, whereas indirect tax is such thing where a trader or an individual can collect from the consumer and pay to the government. If the government through these departmental circulars, calling them as GOs, impose huge taxes, fees, penalty or whatever, people do not pay them out of their earnings or they cannot collect from the consumers. In fact, the constitution does not allow such levies. Of course, local bodies may collect some fees, cess, charge, etc., which should be minimal if meant for controlling purposes, it should be nominal. If it is against any service rendered by the local bodies, it should be reasonable, having some kind of quid pro quo relationship with the service rendered by the local bodies. Exorbitant amounts cannot be collected by local bodies from the citizens. Regarding this, Article 276 Clause 2 comes to play. The amount that can be levied by states from any business, profession, calling or employment cannot exceed 2,500 rupees per annum. Thank you. Thank you for watching this video. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your worthy comments. Thank you.